Locke Meredith. I'd like to invite you to join me on the next Legal Lines, where my guest is Judge Chris Hester. He is a First Circuit Court of Appeal judge, District 2. The district covers almost 1.2 million folks. He's going to talk to us about his expertise gleaned from being an assistant district attorney, a city court judge, and now on the Court of Appeal. So join us on the next Legal Lines with Judge Chris Hester. Hi, I'm Lawyer Locke Meredith. We see this a lot. You're battling an insurance company because of a wreck, not your fault. They're not calling you back or being fair. You're injured, your car's damaged, and you need to see a doctor. You're in pain. You can't work, pay your bills, or fix your vehicle. You need help. Whether you hire us at all, give us a call, 272-5555, or email us at Locke Meredith, Sean Fagan and Associates. Better yet, come see us. We'd be honored to help, and you have nothing to lose. Hello, welcome to Legal Lines. I'm pleased to have on the show for the very first time Judge Chris Hester. He is a judge for the First Circuit Court of Appeals. Judge, fantastic to have you on the show.
Good to see you, Locke. Thanks for having me.
Well, let's kind of dive in. You know, you've worn a lot of hats over your various careers, but let's start from the beginning. So tell folks a little bit about yourself, just so they kind of hear what you say, because it's important.
Sure thing. Born and raised in Baton Rouge, Louisiana. Lived here all my life. I love Baton Rouge, and I don't ever plan to move away.
Same thing here on this side.
Grew up here, went to Catholic high school, went to LSU for my undergraduate studies, and went to LSU Law School after that. While I was in college, I met my wife. She's from Franklinton, Louisiana, Emily, and luckily I convinced her to stay here in Baton Rouge instead of having to go to Franklinton. So we started our family here. We have two beautiful children, a 5-year-old
That's it, right?
boy. That's it, a 5-year-old boy and a 2-year-old girl, and they keep us very busy for sure.
So tell folks a little bit, kind of, you got out of law school, take them through what you did for employment and the various skills that you learned.
Yeah, so after graduating law school, I started at a local mid-sized civil defense firm, did mostly medical malpractice defense work. Enjoyed the work, loved the people there, but I really
That was Watson Blanch?
Watson Blanch, Wilson and Posner, yeah.
Got it.
So loved the work, loved the people there, but I wanted to be in the courtroom a little bit more, and I knew that being a prosecutor was something that was always a goal of mine and something that I kind of thought was a possibility. Luckily enough, I had a conversation with Hiller Moore, applied there.
Excellent district attorney, been there forever.
He was a great boss.
A good man.
In 2008, when he got elected, soon after that, I said I was interested, and then he hired me on as a prosecutor. So after a little more than a year at Watson Blanch, I went to the DA's office and started my career there.
At the district attorney's office, you're now, I guess, part of the government apparatus, so to speak, but it's the justice side. And you're acting on behalf of the public and the government to protect the public, right? Isn't that the role of a prosecutor and assistant district attorney?
So at the DA's office, I was representing the state of Louisiana, handling criminal matters. So we handled everything from misdemeanors to murders.
And you were there 9 years, is that right?
A little more than 9 years, yeah.
And so in the roles that you played there were pretty significant roles, as I recall. Tell the folks about them.
Sure. Well, I started like most prosecutors, started off handling misdemeanor crimes, and then I moved my way up.
And misdemeanors, define that for folks.
Crimes that are punishable by less than 6 months in jail. So things like misdemeanor theft of under $500, or DWI crimes, some serious crimes, but they're not as serious as some of the felony crimes.
Right, the violent stuff.
Exactly. So then I moved my way up to become a felony prosecutor. Eventually,
and again, the felony is just more serious physical?
More serious crimes, punishable by more than 6 months in jail. So became a felony prosecutor and then a section chief, and luckily moved my way up to the section chief of the violent crimes unit, and I was the chief homicide prosecutor.
So explain to folks what the section, when you reference as being the section chief, how many sections are they, and is it just criminal or chopped up in different areas?
Yeah, so there's eight criminal sections, 1 through 8 at the DA's office. There's also an appellate section, and there's a family law section and domestic violence. There's a few other specialties there, as well as a juvenile unit. I was in charge of one of the sections, Section 5, and we appeared in front of the same judge. Probably 95% of our cases were in front of one judge, and we worked together on those cases and moved them through the process like that.
And so as the chief homicide prosecutor, what was the typical, I guess, day in the life of you in that role?
So that was a unique role. My office, actually, I got out of downtown and I was at the violent crimes unit out at State Police Headquarters.
Tell folks what that is real quick.
So it's a unit that at State Police Headquarters, the violent crimes unit houses the major assaults and homicide detectives for the Baton Rouge Police Department and the East Baton Rouge Parish Sheriff's Office, as well as there's some other agencies that have
It's a collaboration, is it not, between the sheriff and the local law enforcement folks and feds at times, correct?
Absolutely, absolutely, and all of that's going on at the same time out there, and it's a great place to work.
State
it's a lot different than what we were doing when I was downtown. I know it just kind of go back and forth periodically. But my role out there was to work with those detectives, track some of the cases that came in to try to handle things as quickly as possible and make sure that communication was on the up and up, and we were doing the best we could on the front end of it.
You guys, in that role, y'all are really seeing, I always say that the general public, I know me individually, we don't have a clue at how much dangerous stuff and violent stuff takes place in our community, do we?
I think it all depends on everybody's bubble. I think it's so different, but it definitely opened your eyes up to different parts of Baton Rouge and different parts of the state at times as well.
And so there's a coordination, and the bottom line, your role was to convince the judge and the jury, I guess particularly if it's serious violent crimes, that it's appropriate to punish this individual, this person, for what they've done. How would that take place?
Yeah, so it starts off very early working with those detectives and finding out what was going on, trying to figure out who the offender was, and then bringing those matters to grand jury or starting the process with a bill of information. Those are the two ways a prosecution would begin. A grand jury, you actually would bring the evidence to a group of people and they would decide what the charge would be. Or you could have a bill of information and you could start the charge off as a prosecutor.
What's so interesting, and I've talked with all the top law enforcement head folks, is that law enforcement at the ground level, the police and such, the district attorneys, particularly the police, they're the ones that go out and collect the evidence, and it has to be done properly. They got to get the right evidence, and they got to make sure it's done the legal way and preserve it so that you guys could actually do your job and protect the public, right?
That's absolutely right. So it's really two separate processes. There's the investigation and there's the prosecution of the case.
Okay. And so you would pretty much try the case to a jury, I assume 99% of the time in those roles?
Mostly it depends. Sometimes the defendant or the defense attorneys would decide that they wanted to waive the jury and have a bench trial. It just depended on the specific circumstances of that case. But generally it would be to juries. And the process was not fast. And I think that's what the people that are involved, unfortunately, become victims of cases,
right,
or have a loved one that might be a defendant in a case, find out that it's not arrest, bill of information, arraignment, then trial 3 or 4 months later. Normally the cases take some time.
And I often hear, that there's plea bargains that are made. Is that a normal process, and what percentage of the cases, and how would you decide whether or not to agree to such?
Sure, and every case
it's like a settlement, right?
Exactly.
In the civil world.
In the civil world, it's the same sort of thing, for sure. And every case is different, but you try to get as much information as you can. And any prosecutor's office can't try every single case that comes in. There's just not enough juries, not enough time in the day.
Right.
So a lot of the cases do resolve themselves. And it's a collaboration between the prosecutors and the defense attorneys on the other side, and sharing information and trying to get the best result that makes everybody happy. And generally the prosecutors, if there's a victim in the crime, of the case, you would speak to them, try to get their
right,
input, and do the best you can to make everybody as happy as you could.
So let's shift gears a little bit. So after that 9 years roughly as an assistant DA in some top roles, you decided to run for judge. Tell folks about that, for the city court judge
I
position.
did. So I actually ran twice. I ran in November 2017. I came up a little bit short, and then I lost that election to Judge Judy Moore Vendetto. And then about a year later, Judge Laura Prosser announced she was going to retire, and I decided to run again, and I was successful and got elected in November of 2018, and then served in that capacity for 2019 and 2020.
All right, and city court, explain to folks how they get access. What are the criteria to get into city court?
Yeah, so city court handles all sorts of things. They handle misdemeanors that take place in the city limits on the criminal side, as well as civil matters less than $35,000.
And this is, all of the events have to have occurred within the city limits?
In the Baton Rouge city limits.
Okay, so not outside in the parish area?
Not outside. We do
limits.
handle, the city court does handle evictions and different things like that, as well as small claims matters that take place as well. So it's a very, very busy court for sure.
Okay, and on civil matters, there's a limit as to the value of the cases. Is that correct?
So the limit at Baton Rouge City Court is $35,000.
And then
so
there's a small
substantial
claims
cases.
court.
Yes.
So we'll talk about that next on the next segment. This is Locke Meredith of Legal Lines. My very special guest, Judge Chris Hester, First Circuit Court of Appeal. We'll be right back. Hi, I'm Sean Fagan of Locke Meredith, Sean Fagan and Associates. Open the phone book or look online. There are plenty of lawyers to choose from. And if you ask any of them, they'll agree that the vast majority of claims settle without ever having gone to trial. And I'll tell you, any lawyer can settle a claim. It's not hard to settle a claim, but it takes hard work to get a client what he or she deserves. At Locke Meredith, Sean Fagan Associates, we have a proven record of working hard for our clients. Whether you hire us at all, give us a call. Welcome back to Legal Lines. I'm very pleased to have on the show for the first time Judge Chris Hester. He is a First Circuit Court of Appeal judge for District 2. Judge, let's dive back to him. You were talking, kind of explaining to folks the roles you had, initially working as just a private attorney on the defense side, then as an assistant district attorney, ultimately in charge of a lot of serious crimes, violent crime unit and chief homicide prosecutor. And then you were elected to the city court. Let's talk about city court a little bit. I'm not sure people understand the difference, say, in city court versus going down to the scary 19th JDC district court. Explain to folks the differences between the courts and the similarities.
Sure, and they're right down the street from each other, obviously.
Right.
As you know, they're very close, and we get a lot of people when you'd have an arraignment in city court and an arraignment at the 19th
They get confused,
JDC.
huh?
It is not uncommon, and almost every single day you have people that show up at the wrong court. Sometimes attorneys show up at the wrong court. But it's so there's a lot of overlap. But like I said before, city court handles smaller matters, so it's misdemeanors on the criminal side, and then there's a limit of $35,000 or less on the civil side. So you're not handling it. There's no jury trials. It's all bench trials. So it's just a trial.
Meaning it's a judge deciding.
It's just a judge is making the decision. There's no jury selection or anything like that. So if you ever get called for jury duty, it's not at city court.
And it's always faster. I mean, if you don't have a jury involved, let's face it, normally it's going to be faster.
It is certainly going to be a quicker process usually on most of those cases. Absolutely.
So the rules of evidence. You know, I know people see these TV shows where the lawyers are saying certain things and doing certain procedures and processes. Is that required in city court? Do folks have to know those rules if they come in without a lawyer?
So everything's exactly the same as the rules of evidence, with the exception of small claims court. City court handles matters $5,000 or less in small claims court, and that's an opportunity for people on cases that might not be as significant to the whole world, but very important to them. They have an opportunity to go get justice for a lot lesser. It's a lot lower court costs, and they can get a trial date usually fairly quickly, and the rules are relaxed there. But as far as the regular criminal matters and the civil matters, the rules of evidence and everything else applies the same way.
And again, in small claims court, but also in city court, you don't have to have a lawyer. I mean, you don't even have to in the 19th JDC, but small claims court is set up for that. That's the bottom line. The amount in controversy is $5,000 or less. If you're above $5,000, but $35,000 and above, or is it $35,000 you can still litigate?
You can still, it's $35,000 is the limit.
Okay, so between $35,000 and $5,000, you've got city court, you got to deal with the evidence rules. Small claims court, you really don't have to know them backwards and forwards.
That's correct.
And so it shouldn't make as big a difference. But the big deal too is it's quick. It's what I call fast justice, and you get it resolved, and you don't have to have a lawyer there necessarily.
You don't have to, and the majority of people in small claims court do not have attorneys. They're pro se litigants, so they're representing themselves. And that does put some more pressure on the judge to explain the process and try to inform everybody as best you can. And you can't practice law for anybody, and especially if it's some people don't have lawyers in the civil matters
Right.
that aren't small claims up to $35,000. And it's a difficult process to try to explain everything you can, try to encourage them to make sure that they are protecting their rights and making sure that they're doing everything right. But they might not be able to afford a lawyer, or they might not want one for whatever reason. So you can't practice law for them, but you can guide them through the process.
And you indicated that in those venues, you actually can get justice pretty daggone quick. It could be a matter of minutes if the other party doesn't show up and you've dotted your I's and got the right evidence, right?
Sometimes the small claims trials you can handle at 5 or 6 in the morning for sure. So you can handle them being very quick, less than half an hour for some of them.
And then oftentimes you would have at least 2 trials in city court?
As far as the regular civil docket, frequently what was happening, now I've been gone for a year, but frequently what happens is you'd have a morning docket and an afternoon docket. And different judges can control that. And if you knew it was a little bit longer case, you can maybe go into that second day. But that frequently didn't happen at city court.
Okay. You know, the legislature just passed a law that lowered the jury threshold to $10,000. Mm-hmm. And you and I were talking before the show that, at least it's my view, that I think that's going to result in a whole lot more folks deciding to go to city court. What are your thoughts on that?
It may. I think
it's going to get overwhelmed.
I think it's to be determined for sure. Like we kind of discussed, you just never know how it's going to happen and how that process is going to kind of continue to morph. If people are going to want the jury trials, if they're going to want to go to city court because maybe it's a little bit more crowded at the district court, and we're going to see how it goes. But
it's going to be interesting.
It will be interesting.
Really interesting. So let's shift gears again, okay? So you then decided, Judge Higginbotham, I think, was forced to retire because of age 70?
She had reached the mandatory
age, and so she had to retire. I know she did not want to. but that's what the legislature mandated. And so that occurred, and you decided to run for the First Circuit Court of Appeals. Tell folks how you came to that decision, and what is your motivation for doing that?
I did. It was an opportunity that I knew I wanted to take advantage of if it came up at the right time in my career, and see if I could run for that spot.
Well, and we didn't tell folks that your father, was a district court judge, 19th JDC judge.
He was a 19th JDC judge for, I believe, 12 years. So he did serve on the 19th JDC. Thank you very much.
I'm sorry for his loss.
I appreciate that. So after 2 years at city court, I actually a little bit before that, about a year before the election, I kind of saw the 19th JDC elections were taking place, and then also there was a Court of Appeal spot that was opening up. And spoke to some friends, spoke to my family, and said, look, this is an opportunity that I want to take, and I think that it's going to work out. And luckily enough, it did. So I decided to run for the First Circuit, had a race, a very contested race, went through a primary and a runoff, and was ultimately elected, and started serving January 1st of this year.
And it's a whole different hat, so to speak, that you're wearing now, because, and I want to talk about that in greater detail. So, at the trial level in city court, in 19th JDC, the judge is basically trying to deliver justice to the parties who are litigating in front of them. And the decision, and correct me if I'm wrong, the decision's impact is basically limited to the party litigants. But in the appellate courts, that's a huge district, and your district too, but there's 16 parishes, is that right?
Yeah, 16 parishes in the First Circuit and 12 judges on our circuit as well. So it is completely different than what I was doing even at the DA's office as a prosecutor to city court. I was handling and seeing so many people on a day-to-day basis. City court, you could easily have 100 people come before you in a day on an arraignment or one of the busier days we had. And now at the Court of Appeal, we're on the back end. It's after the trial has taken place for the appeals, or it's during the writs if there's an issue that comes up during the trial or during the case as well. But we're not handling as much with face-to-face with litigants at all anymore. It's much more dealing with the lawyers and dealing with rulings that have been made throughout that case.
And so for the First Circuit Court of Appeal, I was reading, I think it's like 1.2 million people are affected by the decisions of the First Circuit Court of Appeal. And even more important than that is all the judges within those 16 parishes in those judicial district courts, they've got to pretty much follow y'all's decisions as it relates to any law that they're dealing with. Is that correct?
Sure, absolutely. Cases we decide become cited in other cases down the road and become the settled law for sure. And even in the other parishes, we frequently will see cases from the First, Second, Third, Fourth, and Fifth Circuit cited in First Circuit cases. So it really does have an impact on the entire state of Louisiana.
And I described the trial courts, of which city court was for you, kind of like you're the frontline soldiers up there kind of fighting the wars with the individual folks coming in front of you. But it's a whole different world at the appellate court because all the evidence has been introduced. And so what I'd like to do is talk about kind of the differences between the trial court role and the appellate role and the processes.
Sure. So as a trial court judge, the thing that I was focused on the most is trying to protect the record and make sure everything was being followed, make sure people weren't speaking over each other, and do everything we could to protect the record so if it did get reviewed down the road. All right,
we'll continue this on the next segment. This is Locke Meredith of Legal Lines. My special guest, Judge Chris Hester, First Circuit Court of Appeal. We'll be right back.
I'm lawyer Collins Locke Meredith. Among the most important factors to consider when you're hiring an injury attorney is trust. You trust your attorney will put your interest first, treat you with respect, fairness, and honesty. You trust them to be there for you when you need them. At Locke Meredith, Sean Fagan and Associates, thousands of clients have trusted us to represent them, and for good reasons. Please visit us at LockeMeredith.com to learn more, and whether you hire us at all, give us a call at 272-5555. You have nothing to lose.
Welcome back to Legal Lines. I'm Locke Meredith, and again, very pleased to have on the show for the first time Judge Chris Hester. He is a judge for the First Circuit Court of Appeal, District 2, which basically affects folks about 1.5 to 1.2 million people. Let's dive back in. So we talked about the difference to some degree of being at the trial court level where you're like a frontline soldier is the way I describe it. The appellate court's kind of like the general sitting back on the hill looking through their binoculars telling everybody what to do. Rough comparison, but it always stuck in my head. So explain to folks, you said earlier that at the trial court, you're listening to witnesses, you're getting all the evidence in, the documents, the broken tires, whatever it is that's relevant to the issue that's being litigated. In the appellate court, that's not what happens, is it?
No, it's not the same at all. First of all, you're handling matters on panels at the appellate court level instead of normally at a trial court you have one trial judge or a jury as well, but just one person's making the decisions. At the appellate court level, we handle matters in 3-judge panels usually, and sometimes 5-judge panels, and we can go en banc, which would be the full 12 judges. But so nothing you're handling by yourself. You're handling with 2 other judges and their staffs as well. So there's a lot more eyes on each decision that's being made. Whereas the trial court level, the judge is doing their best to referee the interaction and to make sure that the record is there for somebody to review it if it needs to happen. So it's a completely different animal for sure.
Yeah, I've always, at the trial court, they're trying to decide what is true and what is the law, what is the true fact, and how does that affect the application of the law. And the way they decide whether it's true is they got to get all the real stuff in and analyze it and decide. And of course, a jury could be involved in the process at the 19th JDC. So at the appellate court, though, it's all kind of wrapped up. It's called the record, right?
Yeah.
Describe to folks what the record is.
So it's everything that occurred in the trial court. So we get boxes and boxes and binders of things that come through there, whether it's evidence that's been admitted, it could be copies of depositions, it could be the pleadings that took place, so that'd be the petition and the answer and anything that was filed, any motions were filed. Whereas at the trial court level, you're just creating all of those things.
Right.
So we get to see everything on the back end. Or if it's a writ, we get to see everything that's happened so far in that process.
But it's always in writing.
Everything's
you're
in
not
writing.
talking to a live human being about it.
No, we're not. We're always reviewing the documents for sure. So everything's like that.
And what I love is we were discussing earlier, just that the way that our whole government has been set up is to chop up power amongst as many people as possible, because power can be dangerous, and that's really what a law is. It's exercising power over a person or their property. And so to protect us from injustice, you chop up the power amongst the various branches of government, which would be executive, legislature, and the judiciary. And even in the judiciary, you're chopping up power, as you indicated, by the panels.
Sure.
And so discuss with folks the process. So, I just tried a case and I got my hiney kicked and I don't like it and I think the judge or jury was wrong, and so I provide notice to the trial court, I'm going to file an appeal. Describe the process for folks after that on your side as an appellate court judge.
Sure. So the appellant will file their briefs. The appellee will get a chance to respond to that as well, and you'll get all of that at the panel level. We'll receive all of that information as well as the record from the case. So we'll get the actual what happened, and then we'll get the arguments from the lawyers. And then after that, you can have oral arguments. So we'll set them for a hearing for oral arguments, where both sides get 15 minutes to make their case and get to present what they think the issues. And it's generally an issue of law or it could be an issue of fact or an issue of law, whatever the circumstance is. And they present that to the panel and see where something went wrong at the trial level. And that's normally the argument that they're trying to make.
And the truth is, it's not like those lawyers get up there and give an opening or closing statement. You guys pretty much pound us pretty quickly with your questions, because there's not a whole lot of time. Y'all studied the record and you know what you want to know, right?
Well, so 15 minutes goes fast for both parties. If you're presenting for 15 minutes, and most litigants want the questions because they want to know. They don't want to just repeat what's been written down, because normally the briefs we have might be 20 to 30 pages, and we've seen a lot of that. So most of the time, each judge has some points that they want the person to speak about in front of them, and if you haven't gotten to them pretty quickly, we'll say, hey, can you speak about this? So we can make sure that we cover the things that might be pivotal in making our decision there, or something that we thought was either right or wrong.
And typically, you're not in any way reviewing every single action of the trial court or the jury and how they rendered their decision. It's between the parties as to figuring out what issues they're going to fight about and making sure you guys have what part of the record is relevant to that, correct?
Well, sure, and we've got the entire record, and sometimes we do deep dive into it with our clerks, but frequently we're talking about one or two decisions or rulings on different things. If it's during the trial, and if it's at the end, there's a couple issues that could be brought up. So the lawyers help us focus on the issues that are before us.
So explain the process after oral arguments been made. What is the process amongst the judge?
Yeah, so before the case will be allotted to a judge as primary judge. So you'll either be primary, backup, or third judge. If you're primary judge, you're frequently going to be the writing judge. So as soon as you get those cases allotted to you, you're going to work on your primary. Most of us will work on our primary cases first and try to get them done so we can circulate them to the other judge. And we'll literally write an opinion, circulate it, and send it out to the other judges, and they'll review it and see if they agree or disagree. Depending on the panel and the judges, we'll speak to each other beforehand, and sometimes we all agree, and it's a fairly quick process, and sometimes we don't agree.
So did you say that the decision of who's going to be primary takes place prior to, I guess, oral argument or submission of the evidence, or does it occur after y'all have heard oral argument and everybody's looked at it?
Prior to. So at
So it's
allotment.
random, I guess, in some
It is.
way.
It's randomly allotted. So you'll get a third of them. Each of the 3 judges on the panel, you'll get a third of those cases. You'll be the primary one, and a third you'll be backup, and a third you'll be third judge. And now it can change though, because if the primary wants to go one way and the other 2 go the other way, it switches to who writes the opinion.
That's where I was headed. So,
Yeah.
explain to folks how that whole system of, well, two are for one position and one isn't, and how is that resolved, and how does that affect your rulings and all of that for folks who don't understand or know.
Sure. So it's 3
Got
judges.
about 2 minutes.
Okay. 3 judges have to are looking to agree on this or give their decisions on this, and sometimes we don't agree. And if it's 2 judges that wanted to overturn the trial court and one doesn't, then it'll go to a 5-judge panel. If it's 2 judges that wanted to affirm the trial court's ruling, then it'll be finished. At that point, you might have a dissent, is what you'll frequently hear from one of the other judges as well. And some of those cases go up to the Louisiana Supreme Court, and some of them don't. But you're not guaranteed that appeal to the Supreme Court. You're guaranteed an appeal to the Court of Appeal, and that's what we take it very seriously and try to get our decisions out as quickly as we can.
Let's talk about the scope of review that y'all have. You handle both civil and criminal matters, and typically folks here, there's a lot of deference to the trial court because they're there. Body language you hear is 90%, of communication. It's not just words, so you guys are limited to what you're reading. So there's a lot of deference to the decisions and rulings of the trial court. But sometimes that may not be the case. Explain to folks how that happens.
So there's 2 standards. It could be a manifest error or a de novo issue. So if it's an issue of law. If there's an issue of an interpretation of a law, then we will review it as we were the sitting judge with all the information. If it's a manifest error, we have to determine whether or not that trial judge, a reasonable trial judge, could have found that way.
And what's interesting is I think we're the only state that allows the appellate courts to review the facts if they desire to do so. And I think that's when manifest error is what's required, which is a higher level of inappropriate action.
Exactly. Even if you might not agree with it, it might not reach that level of manifest error.
Okay.
Sure.
Now tell folks, after y'all render your decision, the next step you mentioned, they can take it to the Supreme Court, but they have a right to file an appeal, and y'all can't say, no, we're not going to listen to it, right?
That's correct.
Supreme Court gets to decide typically. So let's quickly talk through that.
So as long as you file everything within the right time frame, you're guaranteed a right to come to the Court of Appeal. For the Supreme Court, it's a little different.
Not guaranteed.
They're going to take cases if they think it's an issue that needs to be decided.
Judge Hester, thank you so very much.
Thanks so much
for
for having
doing
me,
the
Locke.
show. It's been wonderful. This is Locke Meredith with Judge Chris Hester, First Circuit Court of Appeal. Thank you for being with us.